In the history of American democracy, few moments have carried the weight of what unfolded when a federal grand jury returned a 49-page indictment containing 37 criminal charges against a former president of the United States. The sheer magnitude of this legal action sent shockwaves through Washington, legal circles, and households across the nation. What makes this case unprecedented isn't merely the number of charges or the stature of the accused, it's the detailed allegations of a systematic effort to obstruct federal investigators that forms the core of this prosecution. Before diving into the legal complexities and political ramifications that will reshape American discourse for years to come, understanding the exact nature of these charges and what they reveal about the intersection of presidential power and legal accountability has never been more critical. The indictment handed down by the grand jury in the Southern District of Florida represents the culmination of a months-long investigation that began with a seemingly straightforward matter: the retention of classified documents at Mar-a-Lago. According to court filings reviewed by legal experts at the Brookings Institution, what started as a document retention issue evolved into something far more serious: a case built on allegations of willful obstruction, concealment, and false statements. The 37 charges break down into several distinct categories that paint a troubling picture of alleged criminal conduct. 31 counts involve violations of the Espionage Act, specifically 18 U.S.C. paragraph 793(e), which addresses the willful retention of national defense information. These aren't minor infractions or technical violations. Each count carries a maximum sentence of 10 years in federal prison, according to sentencing guidelines published by the United States Sentencing Commission. Beyond the Espionage Act violations, the indictment includes charges that reveal the obstruction narrative at the heart of this case. One count alleges conspiracy to obstruct justice under 18 U.S.C. paragraph 1512K, a statute that criminalizes coordinated efforts to impede official proceedings. Another count charges obstruction of justice under 18 U.S.C. paragraph 1512B(2)(a), targeting alleged attempts to corruptly persuade witnesses or alter evidence. A third count invokes 18 U.S.C. paragraph 1512C(1), concerning the concealment of documents with intent to obstruct investigation. The fourth obstruction-related charge falls under 18 U.S.C. paragraph 1519, which addresses the concealment or falsification of documents to impede federal investigations. Finally, one count alleges making false statements under 18 U.S.C. paragraph 1001(2), a crime that has ensnared numerous political figures throughout American history. Legal scholars at Harvard Law School have noted that this combination of charges creates what prosecutors call a layered approach, multiple pathways to conviction that don't rely on proving any single allegation beyond reasonable doubt. The timeline detailed in the indictment reveals a pattern that prosecutors argue demonstrates consciousness of guilt. According to the charging document, the National Archives and Records Administration first contacted representatives in May 2021 requesting the return of presidential records. By January 2022, 15 boxes were returned to the archives, which discovered 184 documents containing classified markings, a finding that triggered the involvement of the Federal Bureau of Investigation. The indictment alleges that even after this discovery, efforts to fully comply with federal law were incomplete and, more troublingly, accompanied by actions designed to thwart the investigation. In May 2022, a grand jury subpoena demanded the return of all documents bearing classification markings. The response to this subpoena forms the backbone of the obstruction allegations, with prosecutors claiming that instead of full compliance, a coordinated effort began to conceal documents from federal investigators. What elevates these allegations beyond simple noncompliance is the specificity of the obstruction claims. The indictment describes conversations between the former president and his attorneys, including suggestions, according to prosecutors, that certain documents be hidden or destroyed. Text messages and recorded conversations referenced in the charging document allegedly captured discussions about moving boxes of documents to prevent their discovery by investigators. One particularly damaging allegation involves instructions given to a maintenance worker at Mar-a-Lago to relocate boxes immediately before the arrival of the former president's own attorney, who was conducting a search in response to the subpoena. Security footage obtained by investigators and cited in the indictment reportedly shows the movement of these boxes during the critical window when compliance with the subpoena was required. Former federal prosecutor Barbara McQuaid, speaking to NPR, characterized these allegations as demonstrating a clear pattern of corrupt intent, the legal standard required to prove obstruction charges. The classified documents at the center of this case weren't merely administrative papers or routine correspondence. According to the indictment's detailed inventory, the materials included documents marked top secret, sensitive compartmented information, the highest classification level in the U.S. government system. Prosecutors allege these documents contained intelligence regarding nuclear capabilities of foreign nations, information obtained through signals intelligence that could reveal collection methods, military vulnerabilities of both the United States and allied nations, and plans for potential military operations. National security experts at the Council on Foreign Relations have stated that unauthorized retention of such materials creates what intelligence professionals call sources and methods exposure risk, the danger that adversarial nations could deduce how the United States gathers intelligence and potentially compromise ongoing operations or endanger human sources. The potential harm from exposure of these specific documents, according to affidavits from intelligence community officials cited in court filings, extends beyond theoretical concerns to concrete operational dangers. The legal defense strategies being employed reveal the complexity of this prosecution. Arguments from the defense team have focused on several key contentions that will shape the courtroom battle ahead. First, they argue that presidential authority under the Presidential Records Act gave broad discretion over document designation and retention, a claim that prosecutors counter by noting the act specifically excludes classified national defense information. Second, defense attorneys have suggested that a standing order existed allowing automatic declassification of materials taken to the presidential residence, though no documentary evidence of such an order has been presented, and former senior officials have disputed its existence in statements to investigators. Third, the defense contends that negotiations with the National Archives were ongoing and cooperative, characterizing the document retention as a dispute rather than criminal conduct, an argument undermined, prosecutors assert, by the alleged obstruction efforts. Constitutional law professor Lawrence Tribe, writing in The Atlantic, has argued that none of these defenses adequately addresses the obstruction charges, which stand independently of questions about document classification authority. The political dimensions of this prosecution cannot be separated from its legal merits, yet the evidence must be evaluated on its own terms. Public polling conducted by Pew Research Center in June 2023 found that 57% of Americans believe the charges were serious matters that required judicial resolution, though partisan divides were pronounced, with 87% of Democrats and 23% of Republicans expressing this view. The appointment of special counsel Jack Smith by Attorney General Merrick Garland was designed to insulate the investigation from accusations of political bias, following Department of Justice regulations established after Watergate. Smith, a career prosecutor with experience in both public corruption and war crimes cases at the International Criminal Court in The Hague, has maintained strict silence on the investigation beyond official court filings. This approach mirrors the strategy employed by special counsel Robert Mueller during the Russia investigation, allowing evidence and legal arguments to speak through formal proceedings rather than public statements. Historical precedent provides limited guidance for this situation, as no former president has previously faced federal criminal charges. The closest parallel comes from the Watergate era, when President Richard Nixon was named as an unindicted co-conspirator in the cover-up of the break-in at Democratic National Committee headquarters. Nixon's resignation and subsequent pardon by President Gerald Ford prevented criminal prosecution, leaving unresolved questions about presidential accountability that this current case now forces the legal system to confront. Legal historian Michael Beschloss has noted that the founders' vision of checks and balances anticipated the possibility of presidential lawbreaking, but relied on impeachment as the primary accountability mechanism, a remedy that has proven inadequate in modern polarized politics. The question of whether a former president can be prosecuted for actions taken while in office has been answered affirmatively by Department of Justice legal opinions, but the practical implications for American democracy remain untested and deeply consequential. The venue for this prosecution, the Southern District of Florida rather than Washington, D.C., carries strategic implications for both prosecution and defense. Federal court in Fort Pierce, where the case was initially assigned to Judge Aileen Cannon, a Trump appointee whose previous rulings in related matters favored the former president and were overturned by the 11th Circuit Court of Appeals, raised concerns among legal observers about potential bias. The random assignment of federal judges theoretically prevents forum shopping, but the reality of a small judicial district with limited judges meant that case assignment carried outsized importance. Jury selection in this district presents distinct challenges compared to Washington, where the alleged crimes largely occurred. The Southern District of Florida encompasses counties that voted differently in recent elections, creating a jury pool with varied political perspectives. Prosecutors need unanimous verdicts for conviction, meaning even a single juror who views the case through a purely political lens could result in a hung jury, an outcome that would be portrayed as vindication despite being a legal nullity. The obstruction allegations present prosecutors with certain advantages compared to the underlying document retention charges. While classification disputes and presidential authority arguments create complexity around the Espionage Act counts, obstruction charges focus on conduct that occurred after leaving office, when no claims of presidential immunity or authority apply. The alleged attempts to hide documents, encourage false statements to investigators, and thwart a federal subpoena represent actions taken as a private citizen facing a federal investigation. Former U.S. Attorney Joyce Vance has explained that obstruction cases typically succeed when prosecutors can demonstrate a clear timeline showing that defendants knew of an investigation and took specific actions designed to impede it. The indictment lays out precisely such a timeline, with the grand jury subpoena in May 2022 serving as a clear demarcation point after which any document concealment becomes difficult to characterize as anything other than willful obstruction. The evidence collection process detailed in court filings reveals the thoroughness of the investigation that preceded the indictment. FBI agents executed a search warrant at Mar-a-Lago on August 8, 2022, recovering 103 additional documents with classification markings despite earlier representations that all such materials had been returned. The search warrant was approved by a federal magistrate judge after investigators presented probable cause that additional classified materials remained at the property and that prior subpoena compliance had been incomplete or misleading. Photographs included in the indictment show boxes of documents stored in various locations throughout Mar-a-Lago, including a bathroom and shower, a ballroom stage, and a storage room, locations that former intelligence officials told CBS News would fail to meet even basic security requirements for handling classified information. The contrast between these storage conditions and the strict protocols required at government facilities, including specialized rooms called sensitive compartmented information facilities with controlled access and electronic monitoring, underscores the prosecution's argument about the seriousness of the alleged misconduct. Witness testimony before the grand jury, portions of which are referenced in the indictment, came from individuals in the former president's inner circle, creating potential legal jeopardy for multiple parties. One attorney who represented the former president during the subpoena response has reportedly cooperated with investigators after being informed of potential ethical violations in connection with a certification letter stating that a diligent search had been conducted and all responsive documents returned. This attorney's testimony likely provided crucial evidence about conversations and instructions that occurred during the period when prosecutors allege obstruction was taking place. The maintenance worker, who allegedly moved boxes at the former president's direction, has also appeared before the grand jury, according to reporting by the Washington Post, and faces potential charges as a co-conspirator if prosecutors determine his actions were knowing and willful, rather than simply following instructions without understanding their significance. The legal principle that ignorance of the law is no defense applies, but prosecutors must still prove that each defendant understood the wrongful nature of the conduct. A higher bar when dealing with employees who may have viewed instructions from a former president as lawful directives. The national security implications extend beyond the specific documents involved to broader questions about intelligence community trust and international information sharing. Allied intelligence services from the Five Eyes Partnership, comprising the United States, United Kingdom, Canada, Australia, and New Zealand, maintain agreements that rely on strict controls over shared intelligence. Former CIA Director John Brennan stated in congressional testimony that unauthorized disclosure or improper handling of classified information provided by foreign partners can result in reduced intelligence sharing, harming American national security capabilities. The indictment's revelation that highly classified documents were stored in unsecured locations accessible to numerous individuals without appropriate clearances has reportedly prompted review of information sharing protocols, according to reporting in Foreign Policy magazine. The damage assessment conducted by the intelligence community following the Mar-a-Lago search remains classified, but officials who spoke to the New York Times on condition of anonymity described it as identifying specific counterintelligence concerns and potential compromise of sensitive sources. The constitutional questions raised by this prosecution delve into fundamental issues about the separation of powers and the scope of presidential authority. Can a president, while in office, effectively declassify any material simply by deciding it is declassified without following formal procedures? Does the Presidential Records Act provide civil remedies but create immunity from criminal prosecution for document disputes? Can a former president be prosecuted for actions that blur the line between official duties and personal conduct? These questions lack definitive Supreme Court precedent, creating the possibility that this case could ultimately be decided by the nation's highest court. Legal scholars at Yale Law School have published analyses suggesting that while presidential power is broad, it is not unlimited, and actions taken to obstruct justice fall outside any reasonable conception of legitimate executive authority. The Supreme Court's 1974 decision in United States v. Nixon, which rejected President Nixon's claim of absolute executive privilege and required production of White House tapes, established that presidential power must yield to the needs of criminal investigation, a precedent that weighs against sweeping immunity claims. The timeline for this prosecution will unfold over months or potentially years, with numerous pretrial motions, discovery disputes, and possible appeals creating uncertainty about when a trial might actually occur. Defense attorneys have already filed motions challenging the legal sufficiency of the indictment, the propriety of the special counsel appointment, and the venue selection, standard legal tactics designed to delay proceedings and create appellate issues. Judge Cannon initially set a trial date for August 2023, but subsequent scheduling orders pushed proceedings into 2024, creating intersection with the presidential election cycle. The political calendar creates unique pressures, with Department of Justice policy generally discouraging prosecutions that might be perceived as interfering with elections, though officials have stated that this informal policy applies to investigations of candidates, not to ongoing prosecutions that preceded campaign announcements. The tension between the public interest in speedy justice and the defendant's right to adequate time to prepare a defense becomes more acute when the defendant is also a political candidate with claims that prosecution is designed to prevent electoral success. The precedent this case establishes will reverberate through American governance for generations, regardless of the ultimate verdict. If the prosecution succeeds, it affirms the principle that no individual, regardless of previous office, stands above the law, a cornerstone of democratic governance that has been more rhetorical than tested reality in American history. If the prosecution fails, whether through acquittal or hung jury, it may embolden future office holders to push boundaries of legal conduct, calculating that political support provides practical immunity from consequences. The normative effects of this case extend beyond legal doctrine to public perception of institutions. Polls conducted by Gallup show that public trust in government institutions has declined substantially over recent decades, with only 20% of Americans expressing confidence in the federal government in 2023 compared to 47% in 2001. How the justice system handles this prosecution, whether it appears fair, impartial, and grounded in evidence rather than politics, will either reinforce or further erode this fragile public trust. The specific obstruction allegations merit close examination because they form the strongest component of the prosecution's case. The conspiracy to obstruct justice charge alleges that the former president and at least one co-conspirator agreed to conceal documents from the grand jury, defy the subpoena, and make false representations to investigators. Federal conspiracy law requires proof of an agreement to commit a crime and at least one overt act in furtherance of that agreement. The indictment lists numerous overt acts, including specific conversations about concealing documents, instructions to move boxes, and suggested responses to the attorney conducting the subpoena compliance search. The charge of corruptly persuading another person to withhold documents from an official proceeding focuses on alleged attempts to convince the attorney to falsely certify complete compliance with the subpoena. The concealment charge addresses the physical hiding of documents, while the false statements charge concerns the certification letter attesting to complete compliance despite allegedly knowing that additional classified documents remained in unauthorized possession. The evidentiary standard required for conviction creates challenges for prosecutors despite the detailed indictment. Proof beyond reasonable doubt, the highest burden in American law, requires that jurors be firmly convinced of guilt, though not to an absolute certainty. In obstruction cases, prosecutors must prove not just that questionable actions occurred, but that they were taken with corrupt intent to impede the investigation. Defense attorneys will argue that any document retention was based on good faith belief in legal authority and that cooperation efforts were genuine, even if ultimately incomplete. The presence of attorneys advising the former president throughout the relevant period creates complexity, as defendants can argue they relied on legal counsel and therefore lacked criminal intent. However, the crime-fraud exception to attorney-client privilege allows prosecutors to present evidence of communications if they can demonstrate that legal advice was sought in furtherance of ongoing or planned crimes, a showing that the investigation appears to have made based on testimony from the cooperating attorney. The potential sentences if conviction occurs would be substantial, though actual time served in federal prison remains uncertain given judicial discretion in sentencing. The Espionage Act charges each carry 10-year maximum sentences, while obstruction charges carry 20-year maximums. Federal sentencing guidelines would calculate a recommended range based on offense characteristics, criminal history, and aggravating or mitigating factors. Legal experts at the Brennan Center for Justice have noted that first-time offenders rarely receive maximum sentences, and factors such as age, health, and lack of prior criminal conduct would likely reduce any sentence substantially below the theoretical maximum. However, the serious nature of national security offenses and the aggravating factor of obstruction could result in a guidelines range requiring significant prison time. The specter of a former president potentially facing incarceration represents a scenario unprecedented in American history, and one that would create practical challenges for the Secret Service, which has lifelong protective responsibility for former presidents, and for the Bureau of Prisons, which would need to accommodate security requirements in a custodial setting. The international reaction to this indictment has ranged from studied silence from allied governments to thinly veiled satisfaction from adversarial regimes that have long accused the United States of hypocrisy in criticizing their governance practices. Analysis in The Economist suggested that Democratic allies view the prosecution as evidence of American institutional resilience and commitment to rule of law, while authoritarian governments highlight it as proof that American democracy is dysfunctional and that legal systems are inherently political. The soft power implications are complex. On one hand, holding powerful figures accountable demonstrates democratic strength. On the other, the spectacle of a former president facing criminal charges while seeking to return to office projects instability that adversaries can exploit. Former Secretary of State Madeleine Albright wrote before her death that American moral authority in international affairs depends critically on demonstrating that democratic values apply to all citizens equally, suggesting that failure to hold powerful figures accountable does more long-term damage to national standing than the uncomfortable process of doing so. The media coverage of this case reflects and reinforces the deep polarization of American political discourse. Conservative outlets have largely framed the indictment as politically motivated persecution, emphasizing the Department of Justice's alleged double standards and highlighting examples of other officials who retained classified materials without facing prosecution. Progressive outlets have emphasized the seriousness of the charges and the strength of the evidence, focusing on national security implications and the detailed nature of the obstruction allegations. Mainstream media organizations have attempted to present balanced coverage while grappling with the challenge of reporting on a case where one party's presidential frontrunner faces serious criminal charges. The Poynter Institute, which studies journalism ethics, has published guidelines for covering the case that emphasize focusing on evidence and legal arguments rather than political narratives. Though the practical difficulty of separating legal and political dimensions in such a case remains evident in coverage across the ideological spectrum, the impact on the 2024 presidential election creates a feedback loop where legal and political considerations become inseparable. Polling data from Reuters Ipsos shows that the indictment has hardened support among the former president's political base while potentially creating challenges with independent voters who express concern about the allegations. The unprecedented nature of a major party candidate facing trial during a presidential campaign creates scenarios with no historical precedent. Could a candidate be convicted and sentenced while running for office? Constitutional law experts note that there is no legal prohibition against a convicted felon running for or even serving as president. The Constitution's eligibility requirements mention only age, citizenship, and residency. Could a trial be conducted while a defendant is actively campaigning? Logistically challenging but legally possible, creating the surreal possibility of a defendant splitting time between campaign rallies and courtroom appearances. How would voters respond to a candidate convicted of serious federal crimes? Unknown, but polling suggests partisan identity would largely determine responses rather than the legal facts. The document retention issue that sparked this investigation highlights broader questions about presidential records management and the post-presidency transition of power. The Presidential Records Act of 1978, enacted in response to Nixon's attempt to maintain control over White House materials, established that presidential records are public property that must be transferred to the National Archives upon leaving office. However, the Act's enforcement mechanisms are primarily civil rather than criminal, relying on negotiations and potential court orders to compel compliance. The indictment in this case rests not on Presidential Records Act violations, but on separate criminal statutes governing classified information and obstruction, a distinction that defense attorneys argue shows the prosecution is stretching beyond the intended scope of records laws. That process, imperfect as it may be, remains the best method that democratic societies have devised for separating truth from power and holding individuals accountable under law. The stakes extend far beyond the courtroom in Fort Pierce to encompass the basic question of whether America remains a nation of laws or becomes a nation where laws apply selectively based on political allegiance and popular support.